So welcome everyone to the Berkeley Center for Law and Technology's weekly webcast. We have someone who's new to our program, but definitely not new to the university and not new to the world of tech law. Eric Troutman is, I think, probably the most dynamic, definitely the most dynamic and most creative of the TCPA defense lawyers out there. And I thought class actions were boring and uninteresting until I saw Eric's strategy and how he approached this topic. So as a reformed patent litigator, I stand humbled watching this kind of creativity. So with that, I want to introduce you to Eric Troutman and let him take you through some of the more interesting things happening in TCPA that you need to know about. So Eric, all yours.
Absolutely. Thank you so much. And hey, everybody, I am Eric J. Troutman, better known as the Czar of the TCPA world, for those of you that don't know me. I'm a Cal alum. I'm a huge fan of Berkeley, and UC Berkeley, of course, is where I went to school undergrad. And we've got our logo, those of you that follow the program, right there on the field at Cal Memorial Stadium. So if you're watching football, you're going to see the Troutman Amin logo where I am a partner. I'm here to talk to you about the Telephone Consumer Protection Act. Which is a critically important statute for you all to understand. This is the federal crown jewel response to the robocall epidemic. So if you're making any kind of outbound calls, including text messages, including live calls, right, as we're going to talk about, and of course, auto dial calls, AI voice outreach, which everybody wants to do these days, any kind of voicemail that you're leaving, ringless voicemail, etc., any outreach that goes to a phone, you got to listen up, right? Because this is the federal statute that applies to you. And we need to understand that the TCPA is there's a private right of action under the statute, and TCPA litigation, which is your primary risk. Many areas of the law, you're worried about regulatory risk. You're worried about the FCC, the FTC, some regulator coming after you. In the TCPA, you were worried about private lawsuits because, as we're about to find out, this is the biggest cash cow in the history of the plaintiff's bar. So you've got to be prepared. Lawsuits are up huge. Last year in 2024, it was the highest volume TCPA class action filing year in history. And this is a statute that goes all the way back to 1991. 2024, we saw the highest point ever of TCPA class actions. And guess what? 2025 year to date, we're up like 95%. They've doubled from last year. So you took your historic high and you just doubled, right? We're going hockey stick. We're going parabolic. We're doing what revenue needs to be looking like at our institutions, but instead it's the opposite. This is like the worst case scenario for everybody. TCPA cases up massively. This is incredible because, as I already told you, the TCPA is already the largest litigation cash cow in American history. More multi-millionaire plaintiffs' lawyers have been made under the TCPA than under any other federal statute. And some of these guys walking around here, they've got money falling out of their pockets. They are incredibly sophisticated, incredibly intelligent. And unlike many consumer areas, unlike your personal injury law, unlike your ADA suits or your employment suits, where typically the consumer plaintiffs lawyers are very lazy, maybe, not the most sophisticated. In the TCPA, right, we're talking data privacy, telecom, we're talking the highest end federal court complex litigation, multi-billion-dollar claims. These guys are sharks. They are paying their law clerks, their associates, and obviously their partners more than big law attorneys are making. And there's a reason that a firm like Troutman Amin exists, right? We've got 9 lawyers. How the hell do we make enough money to have our logo on the field at Cal Memorial Stadium? The reason is that my rate is $4,200 an hour, $4,200 an hour. How is that possible? That's possible because, again, this is an area of law that is incredibly fast moving, incredibly complex when you get down to it. And of course, you're litigating in complex cases in federal court with billions of dollars on the line. So the plaintiffs' lawyers in this area are incredibly good. These guys cook big law firms, man. They smoke them. Big law shows up to try to defend one of these things. These guys destroy them. In order to defend these suits well, you need specialized counsel that basically just does nothing but this. And of course, that's Troutman Amin. But the plaintiff's bar, the purpose of this slide is this is what the plaintiff's bar does, right? The folks that practice in this area, there's only a handful of them, and they are really, really good. And look at these results that they're driving, right? Verdicts of like $660 billion. We've got like trillions of dollars in penalties that are like stacked up in these cases, like trillions. This is insane. Like this is an insane statute. The amount of damages that you can see in a TCPA suit, it's unlike anything that you could possibly imagine. I remember back in the day, remember the Deepwater Horizon thing when like the bay was filled with oil because one of the BP just like destroyed, the Gulf of Mexico or America, or the hell we call it these days. And I remember the cleanup was going to cost like $40 billion. And I was like defending a case at the time. And I was like, well, that's about half the exposure in this case that I'm handling. It's crazy. Like the TCPA is absolutely wild. So it's definitely something, again, you have to take seriously. But why? Why is it so scary? Well, again, I've got that private right of action, right? And it is $500 per violation, right? So anytime that statute is violated, it's 500 bucks. And when we look at what the statute covers, which we're going to do in the next slide, we see that we're talking about phone calls, we're talking about text messages, we're talking about something that an enterprise does at scale, something that an enterprise might do millions of times in one day. And so if you're doing something a million times in a day, and the risk, if you get it wrong, is 500 bucks, you're talking about $500 million in exposure daily. And then when you think about the fact that the TCPA has a 4-year statute of limitations, just think about how much money you're talking about. How many text messages or phone calls does your institution make every day, every month, right? Multiply that to get to 4 years, times it by 500. And by the way, it can actually go up to 1,500 if there's a willfulness violation. So again, many, 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 many times in the cases that we defend at Trotman Amin, at least the theoretical exposure is in the billions, in sometimes the hundreds of billions. And we've had a couple of cases that have actually trickled into the trillions, which is just insane. It's just insane to think about that. I chuckle because I've now handled over 1,000 of these class actions. And when you stop and think about the total liability that I've defended, I probably defended more in terms of potential outcome, in terms of potential loss, than any other human being in the history of the world as an attorney. And that's a pretty crazy thing to think about. But this last point here is really important, which is personal liability. Individuals can be sued personally, right? Going back to the Deepwater Horizon example, the guy that messed up and resulted in oil dumped into the Gulf, right? They're not going to get sued personally, right? I mean, those guys, even the executives, they don't get sued personally. Sure, BP had to pay some money, but like that's it, right? Typically speaking, under the American way of law, if your company does something wrong or you're doing something for your company and you do something wrong on behalf of your company, you don't get sued personally for that. But in the TCPA, this is something for all of you who are in-house counsel that have business leads that want to be aggressive with marketing, remind them. Actually, under the TCPA, you can be personally sued, Mr. Call Center Operator, Mr. Dialer Operator, Mr. VP of Marketing. These are the guys that caused the trouble, right? The head of affiliate leads, whoever it is that's putting together the program that leads to the allegedly or sometimes actually violative conduct, they can be sued personally. So for their own personal bank accounts, and this happens all the time. There's a bunch of folks that have had to declare bankruptcy because they were sued personally under the TCPA. And I can give you some examples of that if you're interested, but not on this slide, not today. So what does the TCPA restrict? I've given you all the dire consequences. I've told you why you have to pay very close attention, but what does it even apply to? All right. It's very simple in theory. We'll find out it's not that simple, really. Just 2 things, right? Thou shalt not use regulated technology to contact a cell phone without the appropriate level of consent. Easy, right? And second, thou shalt not make unsolicited calls to residential numbers on the DNC for marketing purposes. That's it. If you're marketing, you cannot make unsolicited calls to phone numbers on the national DNC list. Seems pretty straightforward. And regardless of whether or not you're marketing, if you're using certain regulated technology, you have to have the right level of consent to contact a cell phone. This feels fairly straightforward. But unfortunately, the definition of regulated technology under 227B of the statute, actually it's 227A1 and 227B of the statute, is very challenging for people to kind of wrap their heads around. And I don't have a bunch of slides in this presentation on this because we've got some kind of more specific topics we're going to talk about. I think I'll do a later one with you, Wayne, that kind of breaks down regulated technology specifically to give people a better look at it. But at a high level, when we're talking about regulated technology, we're talking about auto dialers, right? What is an auto dialer? That is a topic for a different day, my friends, or you can reach out to Trotman Amin. I'm happy to talk about it, or you can visit our YouTube channel. You'll have more information on that at the end of our presentation here, where we've got a ton of content about the TCPA, including discussion about what an auto dialer is. But it's a very, very finicky definition, and it's one that the courts struggle with across the country, which is one of the reasons why the TCPA is such a dangerous statute. And because it's basically 100% federal court litigation, the district courts are in there kind of making law, right, in a patchwork fashion. And some judges look at the definition one way, some definition judges look at it differently. So it's really, really hard to put your finger down on it and say, this is what an auto dialer is. But a little, preview, it has to do more of the capacity of your system with what the system's latent code capabilities are, as opposed to how you're actually using the system, which is a very challenging concept for people because they're like, hey, look, I'm preview dialing, I'm power dialing, I'm clicking a button to launch the call. I'm not using an auto dialer, am I? The answer might be yes. But again, that's a topic for a different day. Additionally, regulated technology includes, as I previewed earlier, AI voice technology, right? People love this stuff. Generative AI, we want to use this. We want to make outbound calls. This is great. We can fire all of our call center agents. We can just use AI. Maybe, but you've got to have the right level of consent to do that. Pre-recorded voicemails, very, very common. People love to use pre-recorded voicemails, right? Especially in the agent context where you've got a live agent. They're trying to reach that customer. The customer doesn't answer. They just want to push that button and leave that voicemail. Or, of course, ringless voicemail, where you're sending out 10 million voicemails at the same time. You're not even trying to reach the customer, get them on the phone. You're just trying to go straight to that voicemail and leave that voicemail for them. All of these are regulated technologies under the TCPA that require the right level of consent. Again, we're not going to dive too deep into what the right level of consent is in this presentation. You're going to have to tune back in for later presentations. You see how I do. But just at a high level, marketing is going to require express written consent, probably. I say probably because there's a whole mess right now about the FCC's previous rulings under the TCPA and whether or not they're still enforceable because of the Supreme Court case in McLaughlin, which I'm sure all of you have heard about. We'll talk about that maybe a little bit later in the presentation here. But generally speaking, you're going to want to have that express written consent for marketing, and you're going to need a lower level of still express consent, but it doesn't have to be in writing for any kind of an informational message. Looking back at the D&C rules now, this is rule number 2 or commandment number 2. It is a commandment, thou shalt. You cannot make marketing calls to numbers on the D&C. What is a marketing call? Pretty broad definition here, folks. We're looking at anything that encourages any consumer to sell or rent any good or service or to get credit, right? So pretty broad. It does seem to exclude offers to buy. So if you are reaching out because you're a car dealership, you want to buy someone's car, or you're a real estate investor, you want to buy someone's house, in theory, you can send that message and say, hey, can I buy your house, please? And the courts split on this sometimes because the court's like, well, you're obviously trying to make a profit from this. And so therefore, essentially, you're doing reverse telemarketing. We still find that applies. But the majority of cases say, no, 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 no. You actually have to be trying to get that consumer to buy something, not trying to buy something from the consumer. So that's kind of a line. Again, there's a lot of case law around that. I'm not trying to be comprehensive at this point, but just understand marketing versus non-marketing. And of course, when it comes to dual purpose calls, the classic informational message that's really a marketing message. I love the example of the mortgage company that sends around the text message to its servicing portfolio to say interest rates have dropped. Well, that's informational. Interest rates have dropped. But why are they sending that message? They're sending that message because they want you to contact their origination arm and get a refi, right? So this is the kinds of things you need to be thinking about when you're sending those messages. Is it informational really, or is it marketing? The answer actually comes down less to the content of the message than what's in your heart. Because if you're trying to market and ultimately trying to get that consumer to come into your ecosystem and buy something or rent something, you're marketing, even if the message doesn't say that. Additionally, if you're on that D&C list, right, so you've got to be scrubbing the D&C unless you've got either express invitation or permission, which again has to be in writing. The consumer has to reach out to you and say, in writing, please contact me. I'm interested in hearing more about your low mortgage rates, or an inquiry, right? And that can be over the phone, but that's only good for 90 days, whereas written prior express invitation or permission is good forever. And then last but not least, you've probably heard of what's called the EBR, The EBR is when you already have an established business relationship with that consumer and they bought something from you in the last 18 months. Then you can communicate with them, even if they're on the D&C list. But again, all of this is assuming you're not using regulated technology. If you're using regulated technology, then rule number one applies, or commandment number one applies, and you always have to have the right level of consent. Hopefully this is helpful. This is just the primer. Let's move on. Key substantive issues here, I've already kind of highlighted. There's a lot of confusion. Just going to put this slide up. You can take a picture of it. You can think about how do these issues apply to you and your institution. These are the kinds of questions that if you are in-house counsel, you should be thinking through, right? And you should also be mapping out, right? Who are your leads? Who has the IT commandments here, the data sets that you need to understand in terms of both ingesting, what's top of funnel, how are you getting these leads, who are you calling, right? What is being left behind? What kind of data sets do you have? What kind of systems are you using? What CRM do you have? What's your data information warehouse look like? Right? You want to have all this stuff kind of mapped out so that you can really kind of understand, are you getting the right level of consent from the right person for the right use cases? Are you proving it, right? Do you have documented consent? Do you have documented communications that comply with the TSR and the TCPA rules? Something that you should be thinking about. Again, not going to dive too deep into all of this. We've got like hundreds of hours of content discussing compliance issues along this line, as well as, of course, we're on stages across the country talking about this stuff. If you are interested, of course, you can reach out to us. Okay. Again, as I mentioned earlier, there's a huge body of FCC authority that's interpreting the TCPA. Again, beyond the topic of the conversation today, just kind of giving you a taste, whetting your appetite. But as I mentioned already, whether or not this huge body of authority is even applicable anymore, very unclear because of the McLaughlin. I call it the McKesson case, but I said McLaughlin just so that you guys know what I'm talking about. To me, it's called McKesson. The McKesson case, of course, has come out, and it has suggested that there is no longer a need to give any deference to the FCC's rulings. This is a really wild concept because it's unclear whether or not these are just declaratory rulings that the Supreme Court's talking about, or if this applies to the entire CFR, which is the Code of Federal Regulation that the FCC has adopted pursuant to its authority from Congress to implement the TCPA. The Supreme Court uses some very loose language. If you ask ChatGPT, all of the CFR is gone. Now, you want to rely on that, I don't know. But it is very challenging to try to figure out exactly what the lay of the law is today. What we want to be focused on, of course, is the statutory language. And I'm going to give you a little sampling of some of the things that the courts have done recently after the Supreme Court came out. As I've already mentioned, right, you've got personal liability here. This slide, you're going to see, you've probably already seen quite a few pictures, right? These pictures come from my blog. That's tcpaworld.com. On tcpaworld.com, we break down literally every single TCPA case that comes out every single day. And guess what? You can go to tcpaworld.com and read this stuff without signing up. There's no most of the time you go to a website, it's like a paywall, or there's like a bound. You can't get through unless you kind of fill out some information. We don't do that. You can just go right now, and there's thousands of articles, and some of them will be right here that you're going to see a little sampling. So I'd like to put together just kind of some quick slides on the recent rulings that have come out. Here, this is not really a ruling. It's just a reminder to folks in the insurance vertical that these agents get sued personally all the time, right? So if you're looking for a suit against Allstate or Hero Senior Life Insurance Company, you might think, hey, I'm just a little agent. I'm not going to get sued personally. They get sued personally all the time in these cases, as do their brokerage. In the case of the captives, right, obviously the big name's going to get sued, and the big name's going to get sued really no matter what. Sometimes the lead company gets sued as well. Those of you that are not familiar with the marketing game, many times in the independent agent context, these guys are out there. They've got their State Farm, up on their little, their little local shop next to the Ace Hardware or whatever, and they have to get leads. They have to find people to call, so they'll buy leads. Right? These are data sets that somebody gets online. They'll make this purchase. God knows who they're buying the leads from. Many times it's completely invalid leads. They'll accept warm transfers. Many times these warm transfers are coming from call centers in Pakistan. right? I mean, it's a dirty game, that the lead gen game. So if you are in any way affiliated with a company that's buying leads, just recognize it's going to lead to potential class litigation here. And the point of this slide is that if you're the agent individually here, you might get sued, even though really they want to go after the big guys. This is a fascinating new settlement. Again, this is just from August 19th. We're recording this in September. So, very recent development here. This is the first time I've seen a case like this. As I've mentioned, 8-figure settlements, very common in the TCPA world. 7-figure settlements, if you can get one through. But this was an interesting case because the company that was being sued was a small company. I think they only had like 20 million in revenue, and they really had very little in terms of gross profit. And so, they were saying, hey, look, man, we can't afford to settle this case on the terms that you want. We're going to declare bankruptcy. Plaintiff's lawyer, please show mercy. And what the plaintiff's lawyers did to get around that is they put together a $30 million deal that they have to pay for 15 years. So, I mean, that's a long time to have a TCPA settlement hanging over your shoulder. And what's fascinating is even if this company raises capital, the TCPA plaintiffs lawyers are entitled to get 12% of any capital raise that these guys have. So they really thought this thing through. It's really very, very abusive. And unfortunately, it opens the window, if not the door, to these kinds of class litigation settlements against smaller companies. Whereas in the past, they've largely been focused on larger institutions that can afford to write the 7 or 8-figure check in one swoop. Something else to keep in mind, as I mentioned earlier, the TCPA is the federal crown jewel response to the robocall epidemic. As robocalls rise, the pressure on Congress to expand the TCPA and the states to create new mini TCPAs, which are out there. Remember, in America, you got to comply with the federal law, and then you have to comply with the state law of every state that you are calling into. And of course, there's 50 states, and 49 of them have laws that look at marketing. The only state that doesn't, at least as of this recording, is Iowa. Little trivia answer. But as robocalls go up, there's a lot of pressure. Now, I'm the I'm the president of an organization called REACH, that's Responsible Enterprises Against Consumer Harassment. We are the largest anti-robocall outfit in America, as far as I know, and it's a trade organization of lead generators, lead buyers, and marketers who are kind of committed to reaching the highest standards to prevent hurting consumers and harassing them and selling data too much. And there's a really good set of standards. It's a great organization. You should check it out. That's reachmbc.com. But through our efforts, we actually had helped to stop billions of robocalls. And throughout all of 2024, robocall levels were dropping. But in 2025, despite our best efforts, man, they are going right back through the roof. So it's really not a good thing, because as those robocalls rise, not only do consumers get annoyed, not only do you and I get annoyed, but the legislatures respond, and generally speaking, they're not doing the craftiest, most thoughtful stuff here. And so as these regulations get tighter, the laws continue to get tighter, the TCPA litigation continues to get more abusive. You need to continue to pay more attention than ever before. So keep these ideas and concepts in mind. And one example, an immediate response to the recent robocall increase was Texas. Texas, you're supposed to be business friendly, Texas. Texas has come out with an incredibly aggressive new amendment to its telemarketing rules that expand the definition of what is an auto dialer in Texas, give up to $5,000 in penalties for violating its statutes, and have a registration requirement that plaintiffs now can sue you for if you make any marketing calls into the state and you haven't first registered as a telemarketer in the state. And yeah, if you are using a telemarketer that's calling, you can be liable. And if you are the telemarketer that's calling, you can be liable. And again, that's $5,000 per violation. This is a really nasty thing, you guys. This is even worse than the TCPA. So again, as you can tell, this is my this lovely young lady on the screen is my partner, Pooja Amin. We did a great breakdown of hour-long called Texas Travesty. You can Google that, or you can visit our YouTube channel. That's at Deserve to Win. That's our logo, Deserve to Win. The YouTube channel is at Deserve to Win. And you can check out our breakdown of this new amendment, which is a really big deal for anyone that's doing marketing calls into Texas. For those of you who are not, you're like, we don't care. Great, we'll move on. We're going to take a quick break, and it's not really a break. We're going to take a quick little tangent and talk about what the FTC has just done. Again, this is I'm going to be focused on marketers for a second. The FTC now, this is Trump's FTC, and they are very, very aggressive when it comes to lead generators, when it comes to marketing, particularly around insurance products. But really, this is going to apply to any consumer good. So if you watching this are with an institution that is involved in any kind of consumer marketing, you're going to want to pay very close attention to the next 5-10 minutes here. If you're not, you can just go ahead and like skip forward like 5-10 minutes. I'm kidding. You want the CLE credit. But in seriousness, the FTC had two consent orders come out on the same day, both against insurance marketing companies. One was against a company called Assurance IQ. Really interesting backstory to that company that I'm not going to go into, but it's actually very fascinating. And then another one against a company called Media Alpha. Now, Assurance IQ was like an insurance brokerage where you could go on to Assurance, which was at that time owned by Prudential, and you could use it as like a digital marketplace to compare insurance products. Problem is, at least according to the FTC, is that when you got an assurance agent on the phone, they were not going to be as honest with the consumer as they should have been. And although they were not selling in many instances comprehensive insurance products, they were engaging in quite a few tactics and tricks to convince the consumer that the products they were buying, which were really high cost, non-comprehensive products, really were comprehensive. They made other misrepresentations as well, which we're going to take a look at. So, Assurance gets hit with $100 million, $100 million, and Media Alpha, which is a pure lead generator, they got hit for $45 million. And as we're going to see, what's really fascinating and scary about what happened to Media Alpha is they were mostly being hung for things that their affiliates did. The upstream lead generators, upstream publishers that they were buying leads from, who had published content that was a little bit misleading. They, Media Alpha, were getting hung for the content that third parties were using to bring consumers, to trick consumers into coming into their ecosystem, to come in here and look at insurance products, right? But because these front enders were tricking consumers, Media Alpha had to pay about 45 million bucks. I'm going to go through this pretty quick because, again, as you'd expect, on our great YouTube channel at Deserve to Win, we've got an entire hour-long breakdown of this ruling. So what did they do wrong? I want to start with they hired Big Law. You've heard me mention Big Law before. Big Law is great, by the way, and I'm sure many of you folks use Big Law for other areas of law, and they do a very nice job. TCPA, highly, highly specialized. Cannot emphasize enough. This is not a place where you want to just trust the local Big Law guy that's really a complex litigator. He does like other consumer statutes, and it's like, yeah, sure, why not? Let's do TCPA. And you know how this works, right? You've got your partner that does X, and he's great, and he probably is great. And then he tells you, oh, you've got a TCPA suit. You should use my buddy, whoever. Okay. His buddy, whoever, is not great in all likelihood. In fact, there's only like 3 big law firms that have really good TCPA practices. And if you're not using one of them, you're getting jobbed, right? But you know how it works. Your guy, who's great, says, use my other guy. That other guy is not good. But your guy's going to get like 30% of the fees that you pay the other guy, right? So he's going to tell you that he's the best. Conflict of interest, I hate it, but that's the Big Law model. Hopefully you know that, right? When they're doing a referral to somebody else in their firm, they're going to get paid on that. And they're not going to tell you they're going to get paid on that, which again, this is really a state bar issue if you ask me, but whatever, I digress. Big Law handled this defense, if you want to call it a defense, and they really rolled over here and paid, in my opinion, way too much. So let's just start with that. I don't think the settlement really should have gone down the way that it did. I think 100 million out of Assurance is ridiculous, and 45 million come out of Media Alpha for the allegations here. Pretty much criminal. But look, to the extent that these guys were making misrepresentations to consumers or were knowingly letting other people make misrepresentations that they then benefited from, obviously, right? You shouldn't be doing that. That's very, very bad behavior. And those of you watching this, you should know that, you shouldn't engage in that kind of behavior. But let's just take a couple quick looks at the things that were going on here, and we can make our own opinions. For instance, down here, this is the Assurance website. You'll see Aetna, Humana, Kaiser Permanente, right? The allegations, at least, were that although these companies were displayed on Assurance's website, Assurance didn't actually work directly with these companies, which may or may not be true, right? Because my understanding is Assurance actually did provide services that would, in fact, provide coverage from these entities, which I think is what they were trying to communicate to consumers. Nonetheless, the FTC took issue and thought this was a representation to consumers that, in fact, right, there was like this direct line going between assurance and each of these. I'm gonna go really fast through this because it's a little bit less TCPA, more like insurance marketing, which is adjacent to the TCPA and very important for people who are making outbound calls, of course, but maybe a little bit too nuanced for a general TCPA discussion. Here you'll see that there was pictures that have Biden flags and things, and the consumers in the FTC's view were going to be tricked into thinking that these companies were affiliated with the US government. So you got to make sure you've got disclosures that say, no, we're not. There's also allegations of endorsements that weren't being revealed. So here, a doctor who actually was a doctor told people that, hey, look, I tell all of my patients to visit this website. No, she didn't. It was just a lie, scripted, as the FTC called it. And more importantly, they didn't disclose that she was being paid to say the things that she was saying. That's pretty low-hanging fruit, guys. You can't fall apart for things like that. That's pretty obvious. You got to reveal when you're paying someone to say something positive about your company. Additionally, there was a big concern that the commission had that these companies were basically buying spots on Google that were higher than government websites. So for instance, if you Googled, ACA insurance or Obamacare, you would show up with ObamacarePlans.com, which the commission believed was really confusing to consumers because consumers thought, hey, look, this is the Affordable Care Act website. The FTC argued that these companies were confusing consumers because consumers thought that this was the actual government website when it wasn't. It was just, of course, a third-party website, and they were going to get the brokerage fees when they brought people in and would actually then sell those products. To my eye, right, this is one of the places where I was just pissed. I mean, look, if they're doing a great job with their positioning on Google and they're driving clients and customers and they're otherwise being honest, I don't see what the issue is here. But the FTC didn't like it one bit. So something to keep in mind. Very important, though, for those of you, again, who are buying leads, right? And this is something that we see all the time. If we look on the left-hand side, you see at the bottom, right, it says, see my options. Consumers are being told that when they provide their email and their phone number and they click see my options, that they're going to get what? Options. But that's not what happens. Of course, they get led to another contact form. And if we look on the right-hand side, right, you'll see there's a place for the phone number again. You'll see household information, and it says see my plans. So both of these, right, there's one that says see my options. Consumer obviously is believing that they're going to see an option, right? It says up top, your quote is ready. See that? On the right-hand side, it says see plans and prices, right? You feel very good that when you provide all this information, you are going to get what? Plans and prices or a quote. Guess what you really get? You get absolutely nothing. You click that button and you'll get a thanks for contacting us. You'll be hearing from us soon, right? And what happens if you read the fine print, these individuals' data is then being sold, right? This is what's called the lead gen form. This is lead generation. You're looking at it, right? The consumer is told one thing, see my options, see plans and prices. They click the button. All they're actually doing is agreeing to the fine print. The fine print down here, if you read it, says you are giving consent to people on the one hand, it says our network of advertisers. On the other one, it says our marketing partners. And if you click on those hyperlinks, you will see thousands of names of names. So the consumer just agreed to receive robocalls from thousands of different companies by clicking this form. The FTC did not like that. And you, as the lead buyer, if you're working for a company that is buying leads, right, and many institutions, either directly or indirectly, do this exact activity, you should understand that when you're buying leads that are being generated on websites like these, you might be liable. You might not be able to enforce that consent. The court might say, I don't care that you have a click on a form from a consumer that was told see plans and prices because they were tricked into clicking that button because they did not see plans and prices. There was no consideration for this contract of consent that they allegedly provided you. And this is also a very interesting data point. According to the FTC's complaint, there was 171,000 consumers that submitted a do not call contact request in connection with just one of these companies. So, I mean, this is very high volume, right? Then again, it's not really that high a volume. So, if you are an institution that's got 100,000 opt-outs, which is, again, if you're calling millions of people a year, it's not that many. Understand the FTC might be paying attention to you. So keep that in mind. Really, though, I think their biggest crime, if you will, is that these companies had both worked with other companies that had already been hit with FTC penalties. So if your company has worked with Assurance IQ, they've worked with Media Alpha, if they've worked with other institutions that have been hit by the FTC, understand the FTC just kind of follows the chain. They go upstream. They look around to see who the partners of the quote bad guys that they've hit in the past are, and then they come after you as well. I'm not sure why it is that they do that, but I've seen this trend many times, and both Media Alpha and Assurance IQ had been connected to a company called Benefit, which was allegedly a very bad actor who the FTC also hit for $100 million back in 2022. Again, already a webinar on this. We spent an hour on it, breaking the whole thing down. It's very interesting. If you're interested in marketing rules or TCPA as it applies to lead gen or insurance, you should check this webinar out. As I already mentioned, Reach, my trade organization, very good organization, trying to stop robocalls and trying to impose, if not have people willingly accept, very high standards that will stop unwanted calls. All right. So going back to TCPA developments, there's been a wave of SMS cases, that's text message cases, particularly against major retailers. If you are listening to me and you just thought the last 10 minutes was boring because you're with a major retailer, you don't do insurance sales, well, ta-da, now we're talking to you. Very common that a retailer will use an SMS text club, right? We love to use discount codes that we send out to people via SMS. We love to send maybe a daily or a weekly message saying, hey, get 25% off of pumps at DSW, or get 5 cents off a gallon at Shell, right? We see these things all the time. They are leading to a large number of lawsuits. The scariest lawsuits are those that contend that the use of a point of sale system to generate an opt-in for one of these text clubs is invalid. Record scratch. What? Many times the POS is not going to have the right disclosures. They're not going to be visible to the consumer. And they're going to try to use a resulting SMS for a double opt-in that's going to contain the terms and conditions. And many times the consumer is going to say that is the business is going to say that's how they provided opt-in. There's case law now. I don't have it up on the screen, but there's one against Safeway recently that is very suggestive that those are not enforceable because the consumer is not providing a sufficient level of assent to demonstrate that they have accepted the terms and conditions before the marketing takes place. So this is a very big deal. People need to be paying very close attention. But many of these SMS cases are actually not coming out of consent in the first instance, but they are coming out of allegations that there was not they did not honor the stop message. So as you all hopefully know, if somebody replies stop, you have to stop messaging. But following a ruling from the FCC back in April of 2025, you don't just have to honor stop, quit, unsubscribe. You have to honor any, including free form, any clear expression by the consumer that they want your text messages to stop. So we're seeing cases right now where the consumer said, cease and desist. The consumer said, knock it off, leave me alone. I don't want to hear from you again, right? None of these phrases include stop or quit or end, the things that you generally automatically receive, but each of them is a clear and express articulation that the consumer revokes their consent to be contacted. And for marketing purposes, you have to honor that period, full stop. If you don't, you are going to get sued. And that's what happened to Shell. Recently, here on the right-hand side, you'll see Albertsons entered into a $6 million settlement based on SMS messages to DNC numbers. And that case was filed like 30 days before the settlement was entered into, right? These guys, they knew they were in some trouble. But it's not just Albertsons and it's not just Shell. Trust me, we're seeing hundreds of these cases. If you are a major retailer, if you're in any kind of retail vertical, you better be paying very close attention to this trend. If you haven't already been sued, you likely will be. If not for origination issues, like make sure that you can improve that consent in the first instance. than for stopping issues because people are having a really tough time honoring these free form communications. Another big, huge, very, very, very interesting trend, honeypots. So again, we're going to talk at a high level real quick. As you can tell, I'm going like a hummingbird, man. I'm just kind of moving quick from topic to topic. I'm going to give you guys a lot of kind of things to think about, but there's going to be more information available on all these things on our website if you're interested. But honeypot lawsuits, what the heck's a honeypot? So right now, as you know, there's a robocall epidemic. It's been going on since probably about 2016 in our country, and there's a lot of efforts to stop it. For instance, Reach is our effort to try to stop it by getting people together to follow standards to stop annoying consumers, but there's other efforts as well. Some of those efforts include, of course, private apps like your Umails or Nomorobos, which you've probably heard of. Well, these companies, in order to provide analytics to make sure that they understand what the robocalls out there look like so they can better inform their users in terms of what's a robocall and what's not, label it as spam or not spam, and more importantly, block it for their users' benefit, they have what's called honeypots, which are hundreds of thousands of phone numbers that these companies own that they use to, again, pay attention to what's going on out there, right? And they've got AI engines that are kind of listening to all the recordings that they receive, seeing who's calling, seeing who's not calling, right? Taking a look at what the ecosystem of outbound calling looks like in the United States. And if you've got 200,000 cell phones that you're receiving calls on, you're going to be able to have a pretty good window in terms of what the activity for robocalling looks like in the country. And that's why UMail publishes its robocall index based upon the results of its honeypot. But you're also going to have something else. You're going to have a lot of TCPA violations, right? Because if you got 100,000 phone numbers, you're probably getting 500,000 illegal calls a day from companies that are trying to call, hopefully, legitimate consumers and by other companies who are scammers or bad guys from overseas. What No More Robo has started doing is suing people under the TCPA for these violations. They sued, I think it was Synchrony Bank recently, and as you see here, they sued a company called RSI. This is a very scary development because, again, they've got hundreds of thousands of phone numbers, and there is a very good likelihood that your company has called one of these honeypots. So as the risk profile increases, as these honeypot lawsuits go up, it is very dangerous, really, for anyone to be calling, not just because of FTC concerns or carrier concerns or even private litigant concerns, but because now honeypots are going to get out there and start suing you for vast sums of money, not in a class action, just in an individual suit, asserting that they own the right to sue you for all 100,000 of these phone numbers. How do we avoid calling honeypots? Well, there's a lot of tactics, but really you've got to be very sure that you're calling legitimate phone numbers, right, from real consumers who you've contacted or reached on those numbers before. And if you're not, you've got to be using the reassigned number database. You should be using vendors that are looking at the accuracy of the phone number that you're calling, excuse me, the accuracy of the phone number that you're calling to assure that the subscriber matches the person you're trying to reach. And there's a lot of other tips and tricks. Again, you can reach out to us. But again, big development because if No More Robo is going to be able to pull off suing on its own, honeypot numbers is a big standing issue there, obviously, right? They're not a consumer of the phone. They're not using it for traditional phone usage. They're using it to analyze robocalls. Do they have standing? Is there Article 3 standing? Don't know. We'll find out. But this is a new trend that you've got to be aware of. Very scary stuff. As I mentioned earlier, there are different standards for marketing versus informational messaging under the TCPA. I told you I wasn't going to dive too deep into it, but I will give you a quick example. This was an actual text message that was sent as part of a case recently. Mario's AC is reminding you to consider flipping off the breaker to your AC unit during a hurricane. We are here for you. Now, during a hurricane, those of you that don't live in hurricane areas, if you do not turn off your breaker, there could be a power surge when the hurricane comes through, and you could lose your AC, which in the high heat of a Florida summer could be a really bad thing. It could be a real health issue, especially for elderly people. And this message was sent ahead of a Category 5 hurricane that was just offshore. So Mario's AC sends this out, and they get sued. The plaintiff argues this was marketing. Mario's AC was sending out a marketing message trying to get consumers to buy their services. The defendant, they went off and hired Big Law. Big mistake, in my opinion. They brought a summary judgment motion pre-certification. Those of you that are complex litigators, you know, wait a second, you're bringing a certification motion, sorry, you're bringing a summary judgment motion, a dispositive motion before certification? Well, you just waived one-way intervention, buddy, and they did. And so the plaintiff counter sought summary judgment, arguing that this was not an informational message and that it was a marketing message. The court agreed with the plaintiff because that phrase, "we are here for you," suggested that the Mario's AC was looking to have these consumers call them back, potentially to use them for goods and services relating to their AC. A couple of problems with this ruling. First, as I already told you, the content of the message does not determine whether or not a message is marketing. Under the CFR provisions, it is the purpose of the message. So context and is more important than content. And in this particular ruling, neither side even addressed or submitted evidence on context, on what it was that Mario's AC was thinking when it sent that message. That's crazy to me. The second big, in my opinion, screw up by the defense, by the big law firm, they didn't raise emergency purposes as an exemption here. Why not? We've got a Category 5 hurricane coming down. We've got a message telling people, hey, look, if you don't take care of your AC, this could really be bad news. And by the way, that is a health issue. Because again, as I told you, you lose your AC and the power is out and no one can come to help you, and you're stuck in a house in 98-degree weather with 98% humidity, and you're an old person, you could die. So this is actually a very important message that was being sent out, and there is an exemption for emergency purposes, and it just wasn't raised. So this is a company who literally has lost summary judgment to the plaintiff. The plaintiff has won the case substantively before certification. You know that case is going to get certified because you've got that common issue. And now you've got a massive judgment. It should never have happened, in my opinion. But a really good case to tell you the difference between marketing and informational, sort of. All right. Another really fascinating trend in the TCPA world, as you can tell, I really like this stuff because this is what I do all day. And it's just a really interesting area of law. There are people, because there's so much money involved in these cases, as I told you, so much money. There are people who are trolls and they literally just set up litigation all day long. They just go around and they put their numbers into forums, or they have their friends put their numbers into forums, and then they get phone calls and they collect all the phone numbers and then they sue for it. There was recently a decision against a guy named Daniel Human, who had his phone analyzed by an expert, and they found dozens of text messages to other people's names, right? And virtually none to him, right? He had a phone and he had all these text messages, but none of them were to him. They were all to like other names because allegedly he was filling out forms using other people's names or letting other people fill out forms using his number with other names to set up lawsuits. And of course, he'd filed like 90 lawsuits. I mean, the guy was just a real litigator, real troll. Well, there's another case involving Allstate with a guy who was allegedly also a troll, kind of setting up these cases. And what's fascinating is, of course, where do trolls live? They live under bridges and also in internet chat rooms. And so these guys were apparently on some kind of robocall forum, and they were exchanging a bunch of tips and tricks on how to set up TCPA cases, and Allstate found out about it. They issued a subpoena to the forum. The forum resisted the subpoena, but ultimately a court down in Texas ordered them to produce the records. So we're going to reach out to Allstate's counsel, see if we can get a copy of those records. But I just think this is very fascinating. It's something for those of you who are being sued in TCPA cases to think about. You can go on the offensive. And if these guys are setting up lawsuits, you can go and find out what they're chatting to their buddies about, which I think is really cool. So as I mentioned earlier, McKesson has come out, it has suggested now that the FCC rulings are out the door. This creates a real true Pandora's box, right? There's a bunch of bad stuff that comes out of that because it's really hard to know what the law is now. But there's a couple of good things, which is now the defendants can make arguments that they couldn't make before. They could, for instance, argue that cell phones are not residential lines for D&C purposes, which if you stop and think about it, kind of makes sense. But so far, the firms that have been hired to make these arguments have not done a very good job, and the courts have ruled against them. So currently, there is about 8 cases that have come out since McKesson, since the Supreme Court ruling that says FCC rulings are not binding. And yet, in every single one of those cases, the court has still applied the FCC ruling. Now, this could be a little bit of inertia, right? Courts not wanting to depart from the old way of doing things. But if you stop and study the briefing and the results in these cases, you will find that these were not very well positioned arguments, I will say. So it's unfortunate. The plaintiff's bar has been very smart. They've benched my firm, meaning they just don't sue my clients on these issues. And if they do, they'll dismiss the case before we have a chance to brief them. They are very sophisticated. I told you, I was not kidding. These guys are very, very sharp. And so they are intentionally picking on certain lawyers in certain jurisdictions and creating positive case law for the plaintiff's side. And that sucks. But that is also how it is. So those of you that are kind of deep into TCPA issues, you may already know that McKesson's out there and that there's a new body of law that's being developed. What you probably didn't know is that the plaintiff's lawyers are way out ahead of this, and they're being very strategic and creating positive law for themselves and bad law for the defendants. A couple more real quick items, and then I'm going to just cut this off because I think I've given you a really good sample today. There is also a provision that I haven't mentioned yet, another commandment, if you will. Those of you who are doing marketing messages, you need to make sure that your caller ID is displaying the full name of either your company as the marketer or your company as the brand on behalf of whom the marketer is making the call. There has to be that full identification. We know that. And a recent case has suggested that even in the SMS channel, even text messages have to have a caller ID associated with those messages, which I'm not even sure that's possible. Have you ever seen a text message that comes through with caller ID? I'm not sure that I have. So that is something to keep in mind. Failure to comply with this rule is $500 per text message. That is very expensive. Obviously, there is branded caller ID available. And in the RCS channel, right, for instance, with your Apple, you can get branded caller ID for texting. You can. But that is very unusual and not something that is available to my knowledge in the SMS channel. So something to think about. Again, I'm just kind of putting stuff into your brain. You should research this. Again, reach out if you've got questions. I've got more answers than I'm giving you right now. Very last thing I'm going to touch on, which is fascinating. There are two cases, as I told you, after McKesson, you don't have to apply FCC rulings anymore. The FCC has previously said that text messages are calls for D&C purposes, meaning if you send a text message to a cell phone for marketing purposes and that number is on the D&C, you could be liable under the D&C rules. Well, at least two courts have now come out and said, no, the D&C rules do not talk about text messages. They talk about calls, and a text message is not a call. Now, I will tell you, this is contrary to about 100 cases that have said otherwise, but all those 100 cases followed FCC guidance, which the Supreme Court has now said is no longer binding. So two courts have said text messages are not calls. I will caution, at least one other court has said text messages are calls even after McKesson, but this is an interesting development and one to keep an eye on. Wayne, I'm just going to wrap it up there. I've got a lot of other slides, but I think we're at the time. I'll just put this up here so that you can see our YouTube channel if you'd like to see that.
Perfect. Eric, as always, it's fascinating to see the complexity in this area that if you're not steeped in it, you have no idea what's really happening. But I think your points about this plaintiff's bar is incredibly sophisticated. And when you think about it, it makes a whole lot of sense. There's a lot of money here, and plaintiff's lawyers are good. They're gonna press every advantage. So this is for those of us that litigate. I like you. I smile when I see the tactics. I may not appreciate them if I'm being sued under them, but I can appreciate the game that's there. So I really, really love the description you give of all this.
Well, absolutely, man. It's a pleasure to be here. Always happy to support Berkeley Law and hope to be back with you here soon.
Take care.
Thanks, man. Bye-bye.